political and religious views. And they were created to, in my view, create a semblance of a public forum where there could be a free exchange of ideas, and there would be an interchange that was quite, an interchange and exchange of ideas, beliefs, and exposure to different ideas and beliefs, which would essentially be an important part of our experience as growing in the course of growing up in the course of our education. Now you put that together with the fact that CLS and other groups, but CLS has been on the point on this one, would prefer only to admit persons of like faith. This violates anti-discrimination laws that you find in most universities. Now, Professor Tokaji explained the theory that it goes in 2 steps. First of all, well, steps, it's 3 ways. The first step is that this is a limited public forum. Okay, it's not a traditional public forum, so the university can pick and choose who can share the forum and use the forum. And I suppose technically that's true, but the next step is that if it's a limited public forum, then the usual kind of strict scrutiny, clear and present danger test analysis doesn't apply. And the university can regulate the forum using the test of reasonable, whatever is reasonable from the point of view of an informed educator, the court will defer to, which is how the court reasoned the case. And I suppose I will, buy the notion that we are not, when we have student groups at Ohio State, it's not a true public forum in the sense that a public park is a public forum. But the court's notion of reasonableness left me absolutely cold. And the court said that it was reasonable to exclude the Christian Legal Society from our community. You could not be a full member of the community if you did not abide by the university's non-discrimination provision. You were, in other words, to be all but banished. But you could, according to the University of California, and the court, I admit, thought this was very important. You could participate, your group could be on campus insofar as it could use rooms and bulletin boards. But so far as being a recognized student organization on the same basis with any other group, step to the back of the bus, please. And to editorialize, some of that was based on the University of Hastings University's interest in diversity as it saw it, and some of it, frankly, was antagonism toward the views and the beliefs of the Christian Legal Society. Make no mistake about it. Nonetheless, that antagonism was not in the record, and because the challenge was to the policy on its face. And the court, I think, was of the view, as it's been forever, that even if you have some bad motivations, so long as you have good motivations that accompany the bad motivations, that the good motivations trump the bad ones, and if the good motivations are reasonable, then the university can make the decisions to further its view of what a proper academic environment is. Now, let's see what's reasonable. And these are my words, not the court's words, okay? The reasonable policies, it cited 4 reasonable policies. First of all, again, I remind you, this is my editorial take on it, not the court's. You did not invite me to be the objective critique. I've been an advocate from day one on this thing, and I'm going to go down with the flag. Okay. First of all, it is a reasonable policy for the university, for Hastings Law School, to turn groups like the CLS into outsiders because they adhered to their controversial, their adherence, let's say it again because there's a quote here from the court. Turning groups like CLS into outsiders because they adhere to their controversial beliefs I don't share, as I suspect you know, but nonetheless I believe they're entitled to. That it's okay to turn the CLS into outsiders because it ensures that, now I'm giving you language from the court's opinion, the leadership, educational, and social opportunities afforded by recognized student organizations are available to all students. Okay? The second justification is the University of Hastings would not have to undergo the difficult task of deciding whether CLS's religious beliefs and others like them were genuine. So it doesn't have to, really, it doesn't have to look at those things. They're just too hard and too burdensome. Number 3, treating groups like the CLS as outsiders. This is my characterization, but it's true. I'm putting this to, that is my characterization. What I'm about to say is what the court said. Treating groups like the CLS as outsiders, court's language, encourages tolerance and cooperation. And excluding groups like CLS from recognition is consistent with state anti-discrimination laws, which says that exclusion of such groups is okay because their belief system and their discrimination is bad. It also says, and finally, and this is, keep this in mind, and I've said this before, and I think Dan Tokaji stressed it, it's also reasonable because it wasn't a complete exclusion. They could still get contact with the student body. Now, why do I think it's unreasonable to characterize this as a limited public forum in the way that the court did, which says that anything that the administration of the university or the law school says about education, almost anything is reasonable, because reasonableness is a standard, is a fairly low standard, not a standard that is regarded as sufficient to protect fully protected constitutional rights like freedom of speech, the right against discrimination based on race, and the like. Frankly, I think that saying that the university has such a, should be able to protect you as law students, I assume most of you here are law students, against the evil of having a group that excludes non-believers from its midst, including gays, because it views their conduct as inconsistent with their interpretation of the Bible, that this is bad for you. It'll hurt you to be exposed to such groups on an equal basis. It will hurt gays sufficiently who are excluded from the Christian legal society. And therefore, it's okay to exclude the Christian legal society. Flat out, it is the most paternalistic view of how graduate students ought to be treated that that particularly stunned me about the court's decision, because frankly, it's taken straight out of the high school cases. That's where we started with deference to the judgment of educators. And I don't think college students or graduate students ought to be measured by the same criteria as high school students. At least I usually don't think that. There are times. I mean, it seems to me that the point that I started with that most concerns me is the point that I think that this decision will generate essential dishonesty. And I debated about characterizing it this way, but it encourages kind of the spread of that, I think, evil don't ask, don't tell approach to dealing with government regulations, because the Christian Legal Society is going to go down on the sword. It's going to take the hit. And there are other groups that will say, as I know they have said, I'm just going to check the box and they'll leave me alone and I'll have my student organization. So you have my views. I respectfully disagree with Dan on the constitutionality of Ohio State's policy, and I think Dan may have some things he wants to say in response, and then we'll let the students have at it.
You know, I do have things I want to say, but I think my preference at this point would be to open it up for questions. Well, first, applause for Professor. Let's open it up for questions.
He is so damn civilized.
In the back.
My question is, during Justice Kagan's confirmation hearings, there's a lot of talk about her discrimination or so-called discrimination policy against military recruiting. How do you think this decision would affect it if Hastings came out with a similar policy in terms of military recruiting?
Yeah, I'm trying to remember the details of this controversy.
It was that because the Don't Ask, Don't Tell policy violated their non-discrimination clause, they couldn't use the career services office.
Right, because they received, Harvard's, of course, a private institution, not a public institution, but because they received federal funding, as I recall, there's a requirement that Harvard allow the recruiters on campus, and I guess there was some controversy about the legality of that federal policy.
Well, let me have at it, because I think Dan and I both skimmed over one dimension of this, which we may share a view on, which is that the court treated, and which made the case easy for a majority, the court treated recognition as a student organization as the equivalent of a subsidy, because student organizations got some money, which under the Ohio State policy they do not, at least not for any discriminatory activity, which I think is why. They can use facilities, they get office space and so forth. And this, when a university or any other institution gets money, the government is freer to impose conditions than it is when it does so by enacting, for example, a criminal prohibition. So that I think that you have to keep that here. I don't think that changes anything. I think this decision leaves intact that whole area of the law and in fact reinforces it.
Yeah, I'm inclined to agree with you on that.
Professor Tokaji, you've talked in other events about how you disagree with Citizens United and that your fear is that groups that have the money are going to drown out groups that don't have the money. Essentially, the money matters. In your comments, you kind of emphasized that CLS wasn't banned from campus. They could still have meeting space, but if they're not getting the funds that other groups are, do you not have any concerns that without funds you can't put on events, you can't have things like this? Do you have any fear that a similar situation is going to happen in law school contests where without money these groups are just going to kind of be irrelevant?
Yeah, it's a great question, and I guess and a fair one, I think. And I suppose I should say I'm not without apprehension about that point. My hope would be that at Hastings, once this policy is in place, I actually don't know what's happened in the wake of this case, but that CLS would agree not to discriminate against gays and lesbians. By the way, the Supreme Court's decision leaves open excluding people if, for example, they're disruptive, right? So if someone insists on becoming a member of the group and who's gay and lesbian, for example, and is continually disruptive and refusing to allow CLS business to take place for that reason. And CLS could exclude that person for that reason, but not based on their status as a